All right, good morning, everyone. My name is Jennifer Hanks, and I am the president of the NCMA-Tysons Corner chapter. I just want to say I hope everyone is doing well during these challenging times with the COVID-19. And I want to start by thanking Miller and Chevalier for putting this webinar on. I think it's going to be a lot of great information for our members and those in the GovCon community. So again, thank you for joining us today. If you have any questions, I'm sure contact information will be provided. And information on the slides will also be provided as well. So thank you for joining us, and I'm going to let Abby Stokes kick it off for us, and again have a great webinar with us. Thank you.
Thanks, Jennifer. Thank you everyone for joining us today. Today, of course, we'll be talking about COVID-19 and the impact on government contractors. Some quick logistics. Next slide, please. Some quick logistics. We are recording today. We will, like Jennifer said, send out the link to the recording afterwards, as well as the slide deck. So also, if everybody could go ahead and mute your microphones, you should automatically be on mute, but double check you're on mute and minimize background noise as much as possible to make the presentation the most enjoyable for everybody. Also, throughout the presentation, please feel free to ask questions. You can send questions to this email address, events@milchev.com. We will try to address them during the conversation or during the discussion. We wish we could be there with you all in person, but given that we can't, we're trying to make the technology as utilitarian as possible. So if we can incorporate your questions into our conversation, that would be fantastic. But of course, we'll address any questions afterwards. And you can feel free to reach out to any of us at any time now or afterwards about any issues. Next slide. Also, we have to say this is not legal advice. The presentation is not legal advice. Of course, all issues are very fact and circumstance specific. We are happy to give you legal advice depending on your specific facts and circumstances, but please don't take this particular presentation as legal advice. Next slide. So these are our speakers today. My name's Abby Stokes. I'm counsel at Miller and Chevalier. I practice government contracts here at Miller. So I support companies that do business with the government at every stage in the federal acquisition, including contract compliance issues through disputes, dispute resolutions, bid protests, and litigation, of course. I joined Miller after almost 10 years working as a federal acquisition attorney for the Department of Navy Office of Counsel. So I am very familiar with interacting with the government and resolving disputes with the government. I'm joined today by 4 of my colleagues, each with unique areas of expertise. Alex Sarria is a member at the firm. He also practices government contracts. He's supported clients in high-stakes government contracts litigation. Preston Pugh is a member of the firm's executive committee. He's defended employers in several employment cases that were tried before a jury, including discrimination, Americans with Disabilities Act, and FMLA cases. He's also defended employers in government investigations, including OSHA investigations. Erin Sweeney is a member of the firm and is a former attorney with the Department of Labor. She advises clients on all facets of healthcare and employee benefits. And Jorge Castro is also a member of the firm and is an experienced tax lawyer advising businesses on both domestic and international tax matters. He brings broad government experience to his practice, having served as a counselor to the IRS commissioner and as a senior tax counsel in Congress. So we brought together this diverse group of practitioners with distinct areas of expertise for a very specific reason. The current situation is rapidly changing, as we all know, and the impact is, we're all dealing with impacts now that we know about, and there are impacts that will come in the future that we may not even be thinking about right now. So we've thought we would bring together this assortment of backgrounds with highlights, with particular areas of expertise, and provide some highlights for you all of different questions that have been raised to us from our clients about issues that related to COVID-19 that are impacting their businesses. Hopefully we're able to address some questions that you all are thinking about now and maybe flag some that you hadn't considered. Again, please feel free to ask questions now, call us later, these issues are ever changing. So we're here to help. Let us know how we can help as these issues change. Next slide, please. So quickly today we will talk about, we'll provide just sort of put us all on the same page with respect to the current status of the virus. And then we'll talk about some business and legal impacts as a result. So we'll go through some government contracting issues, employment and crisis management, employee benefits, and tax implications. Next slide. So this is just a quick update on COVID-19. This graphic is from the CDC. The blue represents where the virus has taken hold. And interestingly, we pulled this graphic last week and it was very different. So this is really a changing situation. Probably half the map was white last week and now it's almost all blue. You can go to the next slide, please. So like you said, this is a rapidly developing situation. The World Health Organization declared the pandemic, just that you all are probably familiar with all of this. We're just going to sort of set the stage. We're all monitoring the status pretty obsessively, I'm sure, but just to make sure we're all on the same page. So the World Health Organization declared COVID-19 a pandemic on March 11th, 2020. That just means that it's worldwide. The CDC is tracking the total number of cases in the US. Again, this number is rapidly changing. When I pulled this number last week, we were at almost 5,000 confirmed or presumptive positive cases. Last night, we're at almost 55,000, and this number's probably changed between when I pulled the number last night. So this is a very rapidly developing situation. The White House, of course, issued guidance, a 15-day pause. They've told us all to stay home if sick, work from home or school from home whenever possible, avoid social gatherings with more than 10 people, avoid restaurants, bars, avoid travel. CDC has provided similar guidance. OMB has provided a few memos that provide some very helpful guidance. The first one was issued on March 17th. To reduce and reprioritize non-mission critical services. It directs federal agencies to maximize telework where possible and work with government contractors to do the same. It provides federal agencies guidance to approve waivers and delegate decision authority where possible to streamline processes. And there's another OMB memo that is particularly useful to federal government contractors that I encourage everyone to take a look at. It was issued on March 20th, and it's specific to federal procurements. It actually specifically addresses excusing delays as a result of COVID-19, maintaining a mobile workforce, and addresses the concept of increased costs of performance and REAs as a result of COVID-19. Important to remember that the guidance is not binding on contractors. It doesn't necessarily change your contract terms, but it's really useful for getting a real sense of the government's perspective right now. Next slide, please. So just also just to sort of set the stage for our goals today, we are all very cognizant that our first priority as businesses is to keep our people safe and healthy. This is important from both a human perspective and from a business perspective. We also have to work to avoid unnecessary risks to our business, including cost risks. I also know as a former member of the federal acquisition community for the last 10 years, how mission driven we are. We also know from our clients that we're speaking to on a daily basis that everyone's goal right now is continuity and meeting requirements. This is of course critical in a crisis like this. But it's also important to keep in mind from a business perspective that these are the exact times when folks bend rules to get the job done. Both government personnel and government contractors, these are the times when we find bending those rules to get the job done. And importantly, at least on the government contract side, this kind of flexing is the kind of flexing that can get us into tricky legal situations later in the long run. So let's say when we're trying to get reimbursed for costs, or you find that you didn't meet your performance criteria for purposes of your incentive fee. So our goal here today is really to highlight some important areas where folks can get caught up and highlight those areas for you all. So as we're working so hard to get the job done, we're also cognizant of things that we should be doing now to ensure that we avoid those tricky situations later. So with that, I will pass it to Alex. Probably next slide. Yeah.
Thanks, Abby. Good morning, everybody. So just diving in here to into government contracts. So what's happening here? What are we hearing from our clients? No surprise, we're seeing disruptions to labor, supply chains, the ability to travel as a result of this outbreak, and that's impacting contract performance. It's resulting in increased costs. It's resulting in changes to the manner and method of performance that's feasible under particular agreements, and it's resulting in delays. The biggest challenge that we are seeing from our clients at the moment is trying to figure out what to do with your employees. So as Abby mentioned, as we lay out here on the slide, can you go back to the previous? Yeah. As we lay out here in the slide, everybody knows there are a number of federal and state governments issuing substantive directives on what constitutes essential personnel, critical personnel that ought to continue work, while at the same time you're seeing from various states stay-at-home orders, and in some states non-essential business orders, so shutting down those businesses that fall into that category of being non-essential. The sort of high-level view of all of that is, the states are taking the lead in directing the public in general in their respective jurisdictions as to what is necessary and what is not necessary in daily life, including whether or not you should be going into work. The federal government has come behind that and provided guidance on a number of critical infrastructure sectors, so businesses that fall into particular segments of the economy that the federal government has designated as being essential to the continuation of important supplies and services and other functions like emergency response, et cetera, et cetera. The best guidance and sort of the leading guidance that came out on that was issued March 19th by DHS, and that identified at a high level those critical infrastructure sectors. Behind that, the very next day came the Department of Defense, which clarified that the defense industrial base is one of those critical infrastructure sectors, and that personnel who fall into that sector and companies that fall into that sector are deemed essential. Now, primarily those directives are aimed at federal employees and the federal workforce, but they are instructive guidance as to what to be doing as federal contractors. So the way that these directives are interacting at the moment is you've got the federal guidance, and then you've got a number of states who have exempted from state orders many businesses that fall into those critical sectors. Now, a number of states have done a really good job. For example, I'm in Maryland. I think Governor Hogan's order on non-essential businesses being shut down was pretty clear that defense contractors certainly, and contractors who are supporting the intelligence agencies, that those are expressly exempted. There's a little bit of vagueness there as to contractors that are supporting civilian agencies, but I think in general, that's an example of an order that is pretty clear. Other states have been less clear, and in fact, some states, what we're starting to see are maybe going in the opposite direction. Rather than implement stay-at-home orders or implement non-essential business orders to sort of shut down certain parts of the economy, you're seeing governors starting to tell localities in their states that they should not be ordering folks to stay home. So I think in the last 24 hours, the governor of Mississippi instructed localities that they should lift any such orders and that folks should be permitted to go back to work. And in fact, you're starting to see businesses in Mississippi now telling their employees, hey, it's time to go back to work because the governor has said that we're no longer subject to these local requirements. And so, that's starting to, I think, cause a little bit of confusion, and that those conflicting messages from the federal government, from state governments, and maybe even from local governments, that could start to accelerate as we start to see calls from certainly from the White House and from other pockets of the country that are calling for things to try to get back to normal, at least in places where it makes sense to. So, the bottom line here, I think, for most companies and for the folks on the phone here is, number one, determine whether your business falls within one of these critical infrastructure categories. I'm sure most of the companies represented on the phone today have already done that. But certainly, if you haven't taken a look at the DHS and the DoD orders to determine whether or not you fall into a critical category, I would suggest doing that as a first step. The second step is then to look at what your state and your localities are saying about not only whether employees or individuals need to stay at home, or what sort of businesses fall into the essential or non-essential categories, but also what parts of the economy and what industries are exempted from those local orders. And ultimately, one big message here is if it's unclear, seek guidance, including from your contracting officers. For example, whether you've got, if you're in a state or you're in a city where the answer is not exactly clear, consider whether or not a telework option is actually available to you under your particular contract, and work with your CO on that. I know virtually every company on this webinar has probably already started to do that, or is already thinking about doing that. One sort of practical piece of advice that we've started to see is that if telework is not an option, and you just happen to be working on a contract or in an industry where a physical presence is required, a lot of companies have started to instruct their employees to carry letters with them everywhere they go that they could present to a law enforcement official who might say, hey, what are you doing out here? Why are you driving around? And those letters essentially explain why this individual is employed with a company that maybe falls within one of the exempted categories, or falls into the category of essential personnel. And it also provides directions on contacting counsel, your in-house counsel or outside counsel, if you are not permitted to continue to go into work. Next slide, please. So not surprisingly, a lot of the guidance and a lot of the confusion in many cases is resulting in contractors incurring unexpected and increased costs. As Abby mentioned, many companies, I think, just as a matter of good business judgment, are starting to implement telework policies, making additional resources available, health and safety resources available to their employees. But all of that stuff, many of those things come with a cost. And so, you see companies, certainly in the government contract sector, investing in additional telework equipment, so computers, phones, headsets, that sort of thing, and providing them to employees to sort of facilitate the continuation of their work. Purchasing additional IT resources, that includes, buying additional capacity for your networking systems. It also includes hardware, software, and maybe even labor. Your firm may be adding additional IT resources to help with folks who may have issues. You're starting to see a lot of companies provide their employees, as Erin will mention later on, with additional telehealth services, things that allow them to abide by these stay-at-home orders, but also be able to see their doctors if they're not feeling well, either as a result of this outbreak or for other health reasons. And then, implementing additional work health and safety resources, like additional facility cleaning, sanitization supplies, et cetera, for those workplaces where you fall into an essential category or into a critical category and your folks need to actually come in. Another big area that you're starting to see increased costs for for a lot of contractors is, the increased use of PTO and employee benefits. And then also, the struggle with, especially if you are in an in a telework model, what to do about idle labor or loss of efficiency. I mean, one practical challenge here, certainly, our family is running into this is, we're trying to not only do our full-time jobs, but also we're taking care of 2 kids and trying to teach them, right? And so that necessarily disrupts your workday. It can make it more challenging for you to actually be as productive as you might ordinarily be. And it's important to note that a lot of these increased costs come both from, adjustments that companies are making on their own initiative, and also coming from changes that result from government direction or policies like those stay-at-home orders that we mentioned earlier, or some of the federal orders that are designating certain personnel as critical or certain businesses as critical. And that's an important distinction to keep in mind, because ultimately it can make a big difference in your ability to recover your increased cost of performance or your ability to get more time to perform. Next slide, please. So, as Abby mentioned, that OMB memorandum of March 20th, I think is actually a really good resource as well. I agree with her on that, because it contemplates high-level guidance for agencies to at least consider when trying to work through some of the issues that you're starting to see creep up on contracts. So, as Abby mentioned, it affirmatively asks agencies to consider telework options for contracts where that's actually available. It also instructs agencies or guides agencies to consider issuing modifications to their contracts where contract language maybe doesn't contemplate telework, but telework is necessary and actually available. It encourages agencies to grant schedule extensions where either because you're in a telework model or because you have a limited availability or limited ability to implement a telework model, performance may be delayed. And it also, it even goes as far as to suggest that if a contractor fundamentally can't perform, right, cannot implement a telework policy, for example, or assure that its personnel or its subcontractor personnel are able to show up on a regular and consistent basis in accordance with the contract, it suggests that agencies should consider a range of options, right? And really the takeaway here is that these are sort of no-fault options that OMB is suggesting agencies to consider. So things like no-cost terminations for convenience, stop work orders, right, where you just fundamentally would pause performance on a contract for up to 90 days in the first instance, and then maybe by agreement of the parties extend that just so that a contractor may not fall into technical default. And then the other interesting piece of guidance included in this particular section in the memo is that it instructs agencies to not issue negative CPARS ratings. So, contractors' past performance shouldn't be dinged, OMB is saying here, for reasons that are outside of its control. One of the more, I think, important parts of this particular memo is OMB is suggesting that agencies should consider requests for equitable adjustment, either in the form of allowing contractors to recover their increased costs, or in the form of scheduled extensions. And so OMB is not saying, hey, grant every REA that you get, give contractors all the time they need. It's saying, hey, look at these on a case-by-case basis, but in considering those REAs, focus on basic principles, not only of cost allowability, but also in the reasonableness of a contractor's costs. So when you submit an REA for increased costs, for example, purchasing additional IT equipment to support telework, or providing additional health and safety resources to your employees, it's important to keep in mind not only whether or not those costs are allowable under the terms of your contract and under FAR Part 31, but it's also important to keep in mind the amount of the cost that you're tendering, or the amount of the adjustment that you're seeking from the government also needs to be reasonable. And so it pays, I think, to remind ourselves that, the FAR contains a definition of reasonableness. Contractors have the burden of proving that their costs are reasonable. And that's a prudent business person standard. So as your company is starting to think through potential REAs or looking for ways to recover its increased costs, keep in mind that this is not simply a function of looking at what's permissible under your contract and the regulations in looking at the amounts that you're putting forth toward the government and asking the government to reimburse or adjust your contract price to cover. Take a step back and make sure that what you're putting in front of the government would meet that reasonableness standard under both the OMB guidance and also under the FAR. So quickly looking at, the ways in which all of this can materialize, right? The need for what things to watch for as companies, and I know a lot of the professionals on the phone call, on the webinar today are already thinking through these things because it's something that you deal with all the time. I think it just helps to put this situation into the normal construct of government contracting. So, we think about this in really two ways. One is identifying the need for affirmative relief, so your ability to recover those increased costs of performance. One quick note here, and this will be second nature for most of the people on the phone, but there's going to be a difference here in your ability to recover to some extent, depending on how your contract is priced. So if you've got a fixed price contract, your ability to recover your increased cost of performance on a fixed price contract may be different from your ability to recover your increased cost of performance on a flexibly priced contract, so your cost reimbursement or your time and materials contracts. The key here, there's really two keys here, regardless of how you're pricing, how your contract is priced. One is, to the extent that you can get it, obtaining government direction for those, to engage in those activities, or government approval of those activities that are causing you to incur those increased costs. That's always very helpful, and Abby will go over some tips as to make sure that you're getting the government direction from not only the right people but also in the right form. And then the other thing is to make sure that you're tracking your costs, whether you're submitting REAs in the near term or you're thinking of or may think of submitting REAs way down the line here. It's important to segregate your costs out so that you don't end up in a situation where you're just lumping it all together, presenting it to the government, and then maybe being asked by an auditor or an ACO to break down your cost, and find yourself in a situation where you're not able to actually do that. That also goes for costs that are incurred due to government initiated changes, right? So that includes constructive changes, that includes changes that the government is making that delay your performance and your ability to recover from during those suspension of work or stop work periods. If you start to see those on your contract, it's making sure that you're not only complying with the instructions that you're getting from the government, but also documenting your costs and tracking them in a way that would allow you to recover later on. The second category here is the need for defensive relief. And, candidly, we really, have not seen a whole lot of this up until this point, thankfully. I think the government, consistent with the OMB guidance, has actually been pretty flexible and pretty understanding that contractors are in a tough position right now. But as this thing, as this whole situation drags on over time, you may start to see situations where government CEOs are issuing cure notices for performance delays or deficiencies by contractors who've been deemed essential, for example. You might start to see those termination for convenience notices or termination for default notices on certain programs where things are not operating in accordance with or according to schedule or as planned when the parties initially entered into the contract. I'm going to skip over the Defense Production Act here. I'll make a quick note. Stay tuned on that. There's been a lot of, I think, confusion on the DPA, mostly born out of, it's not clear the extent to which the administration is actually invoked and is actually utilizing the DPA. But again, if this outbreak and the conditions in which we are starting to see or seeing materialize on the ground, if those continue to persist, I think the DPA is something that will continue to be relevant in the discussion here. The last thing that I'll mention here is something that may only apply to some of you, but you may also be getting contract opportunities or contract direction to perform work that falls within the definition of unusually hazardous risks under Public Law 85-804, which is a statute in which the government can indemnify contractors for performing high-risk work. So, you know, again, as things progress here, you're starting to see more and more contracts for things like potentially building and operating makeshift hospitals to deal with sick patients, transporting sick patients from one location to another. And it may be that in those particular circumstances, you know, contractors may have a really good argument there that they're performing unusually hazardous work, and so they should be sensitive to the ability to seek indemnification from the government for potential third-party risks, third-party liability risks that may arise from that. Next slide, please. So here, you know, we start to talk about next steps, and I won't walk everybody through all of these clauses, because certainly the folks on this phone are quite familiar with the terms and conditions of each of these. But you know, just a quick note to you know, in terms of next steps, if you have not done so already, you know, we're advising our clients to sort of start with the contract, as you always do, right? And understand the terms and conditions of your contract, not only in terms of what your SOW requires, in terms of performance, things like whether a telework model is actually permissible or not, and seeking relief as necessary, but also understanding, you know, the various FAR clauses and other remedy granting provisions in your contract, just so that you are, you know, prepared, you know, in the hopefully unlikely event that, you know, the government takes action under one of these clauses, or that you need to seek an equitable adjustment of either the pricing or the schedule in your contract. And so, you know, just as a practical matter, it's not only important to understand what does your contract include in terms of these remedy granting clauses, but it's equally important to figure out what is missing, right? So, you know, if you've got multiple changes clauses in your contract, that may be appropriate. But, you know, getting a clear understanding of which would apply and under what circumstances they might apply, that's something that, that's some homework that may pay off down the road here. Understanding how each of these clauses work, right? What are the requirements for obtaining relief? Does, you know, a particular clause require you to provide the government notice within a certain time frame, or there's certain instructions or documentation requirements that particular clauses require you to comply with in order to get more time or to be able to recover your costs? Those are all questions that I think we should be asking ourselves now. And then the last thing I'll mention, it's often overlooked, but you know, special H clauses included in your contract, those are also you know, an area that pays to review. As many know on the phone, you know, the government can include particular requirements in that part of your contract that may be relevant here. And so that's another area to focus in on, in addition to the SOW and these FAR clauses, types of FAR clauses that you see listed here. So turn it back to Abby here, and next slide, please.
Thanks, Alex. So here we just thought we would walk you through a few more next steps, what you should be thinking about right now. These are some things that certainly everybody knows. It's basic contract management tips. Now is the time, though, to remember them and to abide by them as you're getting a flurry of direction from different people, likely, and you're communicating across various different platforms. It's important to pay attention here. So first of all, engage your customers. Hopefully everybody already has strong working relationships with their customers. If you don't, now's the time to establish one. If you do, leverage it and communicate as much as possible. So consider whether you need to alert your customers of increased costs. If you anticipate that costs will be increasing, or your cost of performance is already increasing, consider whether you need to alert your customers of that now. Consider whether you need to request waivers from compliance obligations. So for example, do you need to substitute out key personnel? Did one of your key personnel get sick, or are they stuck somewhere else? Do you need to request a waiver for sourcing restrictions? We've seen that a little bit in terms of compliance with BAA and TA requirements. Provide early notice of potential issues. If you think that there might be an impact to your ability to actually perform, whether temporarily or permanently, early notice is always a good thing, but keep in mind, whenever you do that, you should always accompany that notice with an assurance of continued performance. What you don't want is for that to turn into an anticipatory repudiation situation. Follow government instructions closely and get all instructions in writing. This one is critical. Again, one of those things that we all know, but especially in a time when you're probably communicating with more than just the contracting officer, and you are getting, instructions and conversations with people in various different positions. Remember that you need to get instructions in writing from the contracting officer. So approvals for substituting personnel, or substituting compliance requirements, or approvals for changing performance requirements, those all need to be in writing from the contracting officer. And if you do get stop work orders or termination notices, of course, look very closely at all of the instructions and follow them to the T. And then the final note, which is something we all say, but we can't say enough: document, document, document. Any communications, actions, and costs, those should all be documented, and it will really help you in the long run when you're trying to recover costs, or if you hopefully don't, but if you do end up in a dispute, that documentation is really helpful. And then another point that we've seen quite a bit recently, and Alex touched on a little bit, is begin to, if you're not already, tracking and segregating costs. So costs that are related directly to COVID-19. Begin creating separate charge codes to support future cost recovery efforts. Think about what those charge codes might look like, and begin tracking that. That will help in the long run. Ensure your charge codes and categories and practices, of course, are in compliance with your contract terms, your FAR cost principles, and of course, CAS disclosure statement. And when in doubt, especially on these cost issues, seek guidance from your customer directly is always very helpful, and from your advisors, particularly on these cost issues. Alex mentioned idle labor. There's other labor costs that, for example, the cost of just keeping people ready, even if they're not able to work. Can you charge for that? Maybe, maybe not, but I would not assume that you cannot, but also don't assume that you can. So that is a particular issue that I would definitely recommend seeking guidance on. Next slide. So some questions that we've received that you might have already asked, or you might find yourself asking in the future. Are there any instances, like I just mentioned, where I can pay my employees that can't work but still charge the contract? Are there other creative solutions to continue to pay them? This is all based on the circumstances and the facts, but maybe you have to think through the particular circumstances and the requirements. Can my employees telework based on health guidance, even if the contract doesn't contemplate 100% telework? This is an important question. It's becoming, the answer is becoming more clear as the government has been giving very particular guidance that's really pushing agencies to institute 100% telework allowance for federal contractors where possible, where feasible. We've even seen a Navy command, at least one, had the chief of contracting issued basically a broad modification to all contracts to allow for telework to the maximum extent possible on contracts. So that one is hopefully not bothering people as much now, but it's still an issue. You still have to comply with those contract terms. What should I do if my suppliers or my subcontractors can't deliver? Or what if my supplier can't deliver and the only alternative source that I can find might not be compliant with domestic preference requirements? Can you use that alternative source? What should you do if you're experiencing increased costs or performance delays under a fixed price contract or a fixed price incentive contract? So each of these scenarios are very fact dependent. There is a common theme though that we should all keep in mind. The compliance requirements remain. So your contract terms are still your contract terms, and this includes OTAs. I highlight OTAs specifically because, as we all know, they are an alternative acquisition instrument. They're not going to include all of the FAR terms that we're all very used to and we talk about and we resort to in times like this. So we need to pay special attention to the OTA's actual terms and see what applies in this particular situation. So other compliance requirements in your contracts, including domestic preferences, TAA requirements, cybersecurity compliance requirements in your contracts are still valid. So this is a particular area that folks should pay close attention to, especially with this movement towards 100% telework. Most companies are not in a position or were not prepared from a cybersecurity perspective to have 100% remote workforce, but your contract terms still apply unless they've been changed. The CMMC is still coming, by the way, despite all of this churn. So cybersecurity remains a very important issue, and your contract terms still apply. Labor charging is still a very significant issue, and again, the 100% remote workforce is something to really consider as you're looking at your contract terms, and what procedures do we have in place to make sure that your labor charging is accurate in this particular situation. And of course, the scope of your contract, especially on your fixed price contracts, your scope of your contract remains the same. So any changes to any of these things will really only be allowable and potentially reimbursable with the appropriate approvals. So circling all the way back, get everything in writing where possible from a contracting officer. Next slide. And I'll pass it on to my colleague, Preston Pugh.
Good morning, everyone. Again, thank you for attending this and for your time. Couple of things from the jump. You'll see at the top of my slides, it says employment and crisis management. Now, why do we use the term here, crisis management? Well, obviously, what we're going through right now is a crisis in every sense of the word. Recall that a crisis is an event that has the potential to fundamentally change how you do business, and for some, whether you can do business at all. We're seeing that effect throughout the economy. It also includes situations that can fundamentally disrupt your business's relationships with your stakeholders, both internal and external. Again, something we're going through now. The external part is something that Abby and Alex addressed with respect to the government. The internal part is your employees, and we're going to talk more about that over the next few minutes. Normally, in the case of a government shutdown, like some of you endured last year, or all of you endured last year, you had to decide how to deal with employees who didn't have work. We may be at that point soon. Some may be at that point now. Increasingly, we think we'll get there. But one of the immediate issues that we're dealing with is how do you do the work from home? Because the work is still there right now for a lot of folks. We're dealing with immediate concerns such as employee safety and health, and how do you maintain that? In managing this crisis, employers who are based in this country are dealing with the need to support the mission, which is why we have that on the slide. And Abby spoke about that a little bit. But also the employer's obligation to provide a safe workplace, and at the same time, maintain respect for individual employee rights. And the three of these concepts they should hopefully walk step by step and in concert, but the reality is that some of them conflict in some situations that we'll cover. On one hand, for example, the Occupational Safety and Health Administration, or OSHA, as some of you may know of it, requires you to provide a safe workplace for your employees, to not knowingly put them in harm's way. On the other hand, the source of the potential harm, or in OSHA language, hazard, are your employees and your government customer Why? Because they present the risk of transmitting the virus. And while that may be the case, they still have their own rights too. Go to the next slide. So as you appreciate the tension between these priorities, let's tackle the hardest issue first. And Alex alluded to this a little bit, this first question, right? Are your employees in critical infrastructure positions, such as the defense industrial base, healthcare, law enforcement, or other areas? And if they're in that, how do you balance that against the state stay-at-home rules that many different states have? You know, as employers, that DOD has said that essential critical infrastructure contractors should stay open. We can't shut down. That is a matter of real priority, given the vulnerabilities that can be exploited if we did shut down by folks who are seeking to do harm to this country. DOD is encouraging work from home, but many of you know that with certain contracts, especially those that are classified, your employees can't do the work from home. And so the DOD defines essential in one way, but the problem is some states have their own definition. You understand that DOD's words should override the states, but here's the key question. Do your employees understand that as well? And I dare say that probably a number of them don't. And so how do you communicate that? If we look at this from another angle, let's say you are considered an essential infrastructure contractor, but your employees are rightfully concerned about contracting the virus if they come into work. Again, we go back to the part of the equation that focuses on individual rights. Do your employees have a right to say, no, I'm not coming into work? All right, no, I don't. I'm too scared to contract the virus. I don't know that you, employer, are going to do the things that are needed to isolate employees who may be carrying the virus. And frankly, given the nature of this thing, we don't know who's carrying it. So what do you do as an employer? Those are difficult questions that we're working with companies now. There's a few different considerations. First, obviously, you do have the obligation to make your workplace a safe one. And there are certain things that you ought to communicate to your employees that show that you're actually taking that obligation seriously. There is some case law that says that employees don't have a right to not come to work if they're simply scared of contracting a virus. Now, I think that case law is going to be tested quite a bit over the coming months. But at least right now, that is an established employer right. Once we all do go back to work, and this is another part of the concept, you're going to need to look at what policies you have in place. Do you allow for telework? Yes, people may be back in the workplace in June or July, even if you're not essential critical infrastructure. But are you taking the steps that you need to take? Are you allowing, for example, staggered shifts? Are you offering opportunities for employees who don't need to be at work to communicate by Zoom or by Skype? If you're not, why not? And also, where are you on paid leave? Jorge will talk, I think, a good bit about the Families First Corona Response Act, but understand that that act changes your obligations for those of you who have fewer than 500 employees when it comes to sick leave and how that works. If you take nothing other from the few minutes that we have on employment, note for yourself, and we're happy to provide these documents to anybody after. Note for yourself the federal guidance documents that are on this slide. The government has been good at providing guidance in a number of different areas. OSHA, for example, in their guidance on preparing workplaces, it encourages employers to develop an infectious disease preparedness and response plan, develop policies for prompt identification and isolation of sick people. They encourage employers to develop, implement, and communicate about workplace flexibilities and protections. And also obviously certain controls such as requiring that sick employees stay home. And for a number of folks, again, those who are going to work or will go to work once this finishes, employers per OSHA should provide what's been referred to as PPE, or personal protective equipment. Again, personal protective equipment. Another thing that you'll want to do is, and the OSHA guidance explains this, do your own internal risk assessment. Determine which of your workers are in high exposure risk categories. So in OSHA divides these categories in actually 4: very high exposure risk, high exposure risk, medium exposure risk, and lower risk. Very high exposure risk are those, think of like our healthcare workers who are on the front lines, or even morgue workers who are talked about less. High exposure are folks who may be involved in healthcare, but they're not dealing with patients who have the virus. They're instead in the atmosphere, in the environment, or support staff for those places. Medium exposure includes jobs that require frequent and or close contact with people who may be infected. So out of the healthcare setting, but in a setting where there has been a report that someone got sick, that person might fall in the medium exposure category. And then a lower exposure is essentially jobs that do not require contact with people known to be or suspected of being infected with the virus. Those 4 categories dictate some of the steps that you should take when your employees are back in the workplace. Again, for essential contractors, they may be in the workplace now. One thing you should be certainly aware of too is that even if you're in the essential infrastructure category now, you still have obligations under OSHA to take the steps that you need to protect your employees. Recall that the OSHA General Duty Clause requires that you not put your employees in a hazardous situation, and if you are, you still need to take steps to mitigate. The EEOC memo here, again, it's frankly, it relaxes in some ways some of the strict lines with respect to ADA. It answers questions such as how much information may an employer request from an employee who calls in sick, or when may an employer take the body temperature of employees during the pandemic. We've received that question. Does the ADA allow employers to require employees to stay home if they have symptoms of the virus? And you can tell, by the way, by when this was drafted, that this is before the stay-at-home orders were really implemented across the board. And then one of the things that the EEOC asks or answers, frankly, is when employees return to work, does the ADA allow employers to require doctor's notes certifying their fitness for duty? And there's a number of other questions in that are helpful. And then last, just for now, the Department of Labor document, guidance explaining paid sick leave and expanded FMLA, helps employers understand answers to some of the critical questions, such as how must an employer count the number of their employees to determine coverage under this Families First Act? How can small businesses can obtain an exemption from the act, because there are certainly costs to it, and how do you count employee hours and so forth? So I would ask, recommend that everybody take a look at these documents. The OSHA document here basically tells us that OSHA inspections are going to be either conducted by phone, obviously not in the workplace, and alludes to the fact that they're going to hold off for a little bit while everybody's trying to get their bearings. Can we go to the next slide, please? So, and I want to go through this quickly because I know that we're running short on time. If you are an employer who has employees who are coming into work because you're deemed critical infrastructure, some of the things you may consider. First, you may give a letter to your employees telling them that they are allowed to come to work because they're in this category per the DOD. But in addition to that, you may also take the step of informing local law enforcement that you have to stay open. And again, if you stay open, remember you still have obligations. Cleaning is obviously one of the key steps here. Go to the next slide. Now, this next part is something that Abby referred to. What happens when you're an employer of employees who are working from home? You should know that there is a real risk of contract noncompliance for employees who are working from home. And that, of course, raises concerns under the False Claims Act. And there's already been quite a bit of correspondence between the National Whistleblower Center that represents employees and others who are raising their hand about contract noncompliance and the Department of Justice. There is a focus on looking for potential contract noncompliance that may kind of border into fraud. We know from past disasters over the last 20 years that after something like this happens, it is often the case that there's a number of fraud cases that are brought, right? There's an increase in False Claims Act cases that are brought. So rather than be at the point where you're defending a case, take the steps now that may help you avoid the problem. For example, establish systems for timekeeping and expense reimbursement. Determine the proper means for employee oversight. How will you meet, as Abby said, the cybersecurity standards in your contract? Protect, confidential, non-classified information, or even just things that are deemed trade secrets. All of these things are things that you should think through. We're happy to help you walk through these steps. One of the other two other steps that are critical, I think, here. Make sure that you engage regularly with your employees and be intentional about it. And the reason for that is if your employees are at home and are able to do work from their homes, you need to make sure that they're complying with the contract. And if they're not, someone needs to be able to see it and remind them that that's not how we perform this contract. We need to do something different, right, than what you're doing. This is one of the problems with everybody kind of going to their own silos. If they're in the same workplace, then they're able to see how everybody's doing the job, maybe even learn from each other the right ways to comply with the contract. But if they're not, then you can have non-compliance kind of feed upon itself. The last thing, think about creating a peer-to-peer communication strategy. Again, through what means will they communicate? Phone calls, video calls, other things. Those are important. Go to the next slide. We won't dive into this because we don't have time to do it. But consider that when normal business resumes at the end, there are going to be a number of things you're going to want to do. Again, normal business is not really normal business. Normal business as of June or July is not going to be normal business as of June or July of 2019. We're still going to have the virus in some way, shape, or form around us. And so you're going to need to think about the steps that you take when you find employees who have contracted a virus. What do you do? You know, self-quarantining, sending them home, things of that sort. But at the same time, remember that they have rights themselves under the FMLA, the ADA, the Americans with Disabilities Act, where they can ask for a reasonable accommodation. And then there are, of course, state and local law equivalents. We'll go to the next slide. All right, and now I'll turn it over to Erin Sweeney to talk about employee benefits.
Thank you very much for unmuting me. I was talking to you a little bit before I got unmuted, but we're going to dive in here and talk a little bit about how you as an employer can respond to your rapidly changing employee health needs. And I'm starting here with testing. You know, testing, as some of us have alluded to, testing is a lot different place than where we were even last week. But we've moved from the place last week where testing was simply unavailable, and even first responders and healthcare workers who had been exposed were not able to get testing. But now we are in a place where generally testing is available for symptomatic individuals, also for healthcare workers who've been exposed, and also first responders. It's still true, though, that you're not able to get testing for asymptomatic individuals. And there was a lot of pressure early on that, well, we should test and get everyone who's asymptomatic to take the test so that we can map out the context and really understand and be able to take a look at where the virus is moving. But we're still not there yet with our testing capacity in this country. But we've moved a little bit from can you get the test at all, who can get it, to payment. So who's going to pay for the testing? And because, you know, originally when we were first talking about testing, of course, health plans didn't address this issue, and typically there's a lot of employees who have a high deductible health plan, meaning that they have to satisfy a pretty significant deductible before they're able to get access to health care under the health plan. And the concerns that were raised by our infectious disease experts in this country is if you rely on people who have, you know, a $1,500 or $1,000 deductible, and you tell them that they have to satisfy that deductible in order to get the test, then people are going to forbear and they're not going to get the test. And as an infectious disease matter, it's critical and very important to make certain that we get the testing out across the board. And so Medicare was first out of the box on this. On March 5th, Medicare made it clear that any provider that is supporting a Medicare population is able to obtain the testing at no cost share. They're able to make that available. The government made it clear that providing no cost sharing on the testing for our Medicare enrollees is not an anti-kickback violation. So that's where we started with Medicare. Then a number of carriers came out and said they were voluntarily going to, just as a matter of being asked by the White House. The White House had a meeting with the major carriers in the country where the major carrier said, yes, we'll provide this at no cost and no cost sharing. But what we have, though, is, you know, that's the insurance carriers and their fully insured products. The question is what happens on the self-insured side of the house. And so this is where employers don't have an insurance product, but they're making the decisions themselves. And so what we've had is a little bit of the coronavirus two-step on this. And, you know, Jorge is going to talk to us in greater detail about what CARES provides. But the second level of coronavirus legislation from Congress, Families First, what that provided is it was sort of a step in the right direction. What Families First said is that if you have an FDA approved test, that that the providers and carriers are required to pay for that first dollar. You can't have prior authorization, any health visit associated with that testing, that would also be covered. But then, of course, as soon as Families First was enacted, then everybody started to look at it and say, wait a minute, we've missed some pretty big holes here. Most of the tests that are out there are not FDA approved. That, you know, originally the big bottleneck in testing in this country was that CDC first had indicated that only CDC tests could be used. And this is from, you know, long tried and true process in this country of trying to manage SARS, MERS, other infectious diseases, that having one test can provide reliability. But unfortunately, as we know, the first tests that were prepared by CDC simply didn't work. And so we lost several weeks while the government then turned and said, okay, hospitals can create their tests, private labs can create their tests, and those are now moving online. But what wasn't addressed in Families First was that the only cost sharing language related to FDA approved, where most of these processes, while they're being fast tracked, they're simply not FDA approved. So what CARES does is it expands to any laboratory or testing that's in the process or seeking even FDA approval. So that's going to be covered. Also, there was a big concern about surprise billing, that really Families First really didn't address the fact that there could be a huge balance bill that would be provided to the participants. And so what CARES does try to do is allow for a network payment. So if it's an in-network payment, that Families for or CARES says that it has to be paid at the negotiated rate. But there's another provision that is intended really to address the out-of-network situation by saying that the provider has to publish on their website what is the cost of that test. I mean, that's got some, other concerns, because then the provider can really just say whatever they want. They could say, it's $1,000 a test as long as they publish it. And so there's been some concern of how that's going to impact the plan environment. And also, there's nothing explicitly indicated in CARES that makes clear that that there couldn't be a bill provided to participants. And all of the surprise billing and balance billing legislation does try to address that, but this one doesn't quite get there. So, we may see even more on that. Now, moving on to telehealth, as we have alluded to earlier, we are now in a very different situation than where we were last week, which is to say that the Internal Revenue Service issued guidance in March saying that treatment for COVID-19 testing and treatment, that those individuals who have those high deductible health plans, that they can get access to their benefits without having to satisfy the deductible. And again, this comes from our infectious disease experts making it clear that we need to make sure to push this coverage out, because we can't have people getting sick that are not attending to the virus. But what has now transpired in a week is, hospitals and doctors' offices are simply not seeing anyone unless it's an emergency. And really what we saw last week was hospitals moving all of their as many beds as they can to ICU beds, and shutting down all of their clinics, all of their outpatient facilities, and moving then to a virtual platform only, telehealth only, except for the emergency room. So you have hospitals delineating between the emergency room, people coming into the emergency room that are not coronavirus patients, and then everyone else has to be managed through the emergency room. And so the question is, what to do then? How do people get access to healthcare? And so what we have been seeing is a number of providers have come out and said, well, we're going to cover telehealth. We're going to cover telehealth for everyone that's in the health plan for every other visit that you need. And this is also particularly interesting that some of the carriers have come back and said, we're going to cover your whole workforce. We're going to provide the snap-on coverage. We're going to make this available to everyone in your workforce, even if they're not in the health plan. And of course, down the road, that has issues under the Affordable Care Act, because if you're providing a snap-on benefit to a tranche of employees employees, then this becomes a health plan. And so, I'm going to touch on, just give you the highlights of the rest of the items on my slides. I wanted to make sure that everyone understood that HHS has given waivers on telehealth. So what this guidance provides is that even if you don't have a business associate agreement with your telehealth provider, that what HHS has said is that you can go ahead and move in the good faith provision of telehealth, that even if you don't have a business associate agreement, as long as it's what's called a non-public facing remote communication. So what this is FaceTime, Facebook Messenger video chat, Google Hangouts, Skype, but what's not going to be covered under that non-public facing communication are Facebook Live, Twitch, TikTok, these types of that are public in the public domain. Those are not going to be under good faith. Wanted to point out here that 11 of the states have opened up a special exchange enrollment period. So if your operations are in one of the states that have their own exchange, special enrollment periods have opened in 11 states. There has been a lot of requests to the federally facilitated exchanges to open for a special enrollment period, and that's the 33 other states that are run by the federal government. So far, we haven't heard additional word on whether that's going to happen. The last item on this page is a second open enrollment. Been working with clients who are trying to map out how they might reopen open enrollment to capture those employees who simply did not elect coverage the last time. And I would say these negotiations and discussions can be pretty tough sledding, because even if you're self-employed, have a self-employed product, you have to deal with the fact that you have a cafeteria plan that's providing the premium payments, and you have tax issues about when you can obtain a pre-tax benefit. So I've been looking at that for a number of employers. And if you go to the next slide. I'll also have a number of employers that are looking at what's going on with their workforce, people who are on unpaid FMLA leave, and what they want to do is they want to be able to say, well, I know our policy was once your unpaid FMLA leave ends, you have to then elect COBRA, but we want to keep you on your benefits plan. And so what this is important to recognize here is that you need to coordinate closely with your insurance carrier if you have a fully insured product, because you can't just grant people additional benefits without working closely with your carrier on this. And I'm working with a number of employers who are trying to make this happen. Families First Paid Leave, Jorge is going to cover, but I wanted to keep it just a note here that with respect to keeping the benefits all in one package. But I did want to also point out that there are additional issues that we're just starting to deal with now, because we're moving into the surge phase of this virus. We are anticipating at this point that New York City is likely to peak in the next 3 weeks. And so while last week we were talking about issues associated with quarantine, such as what to do if a patient is in an acute hospital setting, but the health plan only, but then they get better, and so they no longer meet the definition of acute health. Well, at least what we've heard from Medicare, and this is again their early guidance on March 5th, was that if a person is in an acute hospital facility and their symptoms change, so they're no longer qualified to be in that acute hospital facility, but they're there for quarantine reasons, that Medicare is going to continue to pay for that coverage at that higher standard of care, because that person can't leave due to quarantine and of course still have a private room. So those issues remain in play, but we've also heard from the governor of New York State that New York is going to be undergoing a variety of different treatments. We know that people who have recovered from the New Rochelle hotspot, they are donating their plasma, and innovative treatments have been used with that plasma that is being given to people who are sick. And the question of those treatments and coverage for those treatments as well as Governor Cuomo indicating that they are trying to split ventilators so that people get half the time on a ventilator. The question of what is going to be covered, how that's going to look. And then the last bullet point is just, the sheer surge care, because, we talked a little bit about sort of the dangers involved, and they're setting up those very large morgues in New York City and hazard pay along those lines. But just surge care alone raises a lot of issues of people being provided hospital services, in the Javits Center in New York City, which is now being retrofitted to become a hospital, and how that's going to work. So I just had one last note about asymptomatic individuals. We still don't have guidance on that, but as we know, there's just a lot of moving parts here, and so we expect that our regulators are going to deal with the biggest fires first. And so with that, I'm going to turn it over to Jorge, who's going to talk to us about the tax issues.
Great, thank you very much, Erin. So we're just going to cover briefly kind of what Congress and the IRS have been doing, what they're currently doing, and the outlook for the next couple of months. The tax base, I will say that it's very fast paced right now. Congress doing a lot of changes, temporarily, but a lot of changes that would certainly impact a lot of your businesses and your financials. So let's quickly start with what Congress has recently done. And as Erin and Preston talked about a little bit, the Families First coronavirus bill, which is, we consider for us here in Washington, kind of the second coronavirus relief package, HR 6201. And the one prominent, tax provision in this bill is the payroll tax credit for paid sick and paid family and medical leave. It's 100% refundable. So it's a very robust credit. That said, it only applies to those businesses with under 500 employees. There's a similar credit structure for self-employed individuals as well. So like I mentioned, that was signed by the president March 18th. So that's currently law, and IRS and DOL, I know, are still continuing to put guidance. There was already a first tranche of guidance that they put out a few days ago. I suspect more is coming. Also, on the recent action front, the IRS, as you've probably seen in the news, they made an announcement recently to make to have a 90-day delay on tax payments at the federal level. This applies, so payments that would be otherwise due April 15th would now be due on July 15th. This applies to payments of up to $10 million for corporations and $1 million for individuals. Also, that includes no penalties and interest as well. That's also put off. Also, for filing purposes, and I know this was a bit of confusion for a few weeks there, the IRS decided recently also to delay the tax filing deadline to July 15th as well. Applies to both individuals and businesses as well. One thing just to caveat, there's no uniformity at the state level. So we've, and there are a variety of states that obviously differ from what the IRS has done. So something to keep in mind, and just to verify with your accounting and tax team. Virginia, for example, when I recently saw, they don't align with the IRS. So Virginia, where most of you probably reside, just something just to keep in mind, that there's no uniformity there with the IRS. Next slide, please. So what is Congress currently doing? And there's been a lot of back and forth in the last couple of days, but they are, I knock on wood, they are at the verge of passing kind of the third coronavirus relief package, which is as of now the largest tax package that Congress is considering, aimed at providing immediate tax relief to workers, families, and businesses. The major theme for the bill is hitting, providing relief to impacted sectors, and injecting cash as soon as possible. Just to give you an idea, this bill in total is about, has a cost to the government of about $500 billion. So extremely big, very robust, and there are a lot of key provisions, which I'm just going to run through quickly, that could impact your businesses. And one thing to mention as I go through these provisions is that a lot of these provisions are actually temporary. Obviously, they're not meant to be permanent. But as Congress, often does, is a provision that starts being temporary could obviously be extended. So something to keep in mind. But I'll just quickly start with the major tax provision at the individual level, which is what we've been hearing about a lot. These are the recovery rebates, which are about $1,200 for individuals, about $2,400 for families. Rebates that the IRS would start issuing in a matter of weeks. Those rebates do have phase outs, however, of about $75,000 for individuals and $150,000 for families. So that's when the phase would start to kick in. On the business side, another prominent provision is the employee retention credits for employers. And there's a bit of a history there with this provision that's been used in the past for similar economic environments. This is a fully refundable credit to about 50% of wages. So for those employers that have retained employees during this crisis, this is a significant provision. And just to give you an idea, the price tag on this provision is about $54 billion over a 10-year budget window. Also, there's a delay of employer payroll taxes for 2020, and also for the self-employed. There's also net operating loss relief. And just to give you a bit of history on this relief and on this provision, and as all of you are currently experiencing and can imagine, this year is going to be a challenging year financially. A lot of businesses are going to be facing a lot of losses. Before 2017, a business was allowed to carry back any loss to previous years and then get a refund. That was done away with in 2017. So there was a lot of activity around this provision to make modifications again during this current crisis, and Congress responded. So now, if you have significant losses this year, and perhaps that's based on your taxable income, or you have the option of carrying it back up to 5 years to past past years where perhaps you had more taxable income, and you can apply for a refund for those back years. Also, there are significant limitations that are removed based on income limits as well, and also allows the loss to be fully offset as well. The price tag in this provision is about $25 billion over a 10-year budget window. So it's another one of the more significant provisions, and one to keep in mind, especially during these times. A couple of other provisions are enhancements to the charitable contribution deduction for both individuals and for employers that are making charitable contributions. Those limits have been increased. That's enhanced. Also increases the deduction for business interest expensing as well. And also there's relief for the corporate alternative minimum tax as well, which Congress did away with in 2017. However, those businesses that were in a corporate AMT position were able to convert to credits, and now that can be used for a refund as well. Next slide, please. And actually, just to pause real quick there. So just to give you the current posture of this bill, the third relief package, the Senate passed it last night. 96-0, strong bipartisan showing. There was a lot of negotiating during the day. Actual text of the bill was not released until last night. So that's now being presented to the House. The House is going to come back, is going to consider the bill come Friday. The goal is to try to pass it by unanimous consent, and that means that members in the House who are currently back in their districts, they would not be required to come back and vote. It would just pass by unanimous consent by a voice vote. However, what's a little tricky about that is that every single member of the House, all 435, have to consent to that. And that's not always hard to do. So, when any one member objects, that can delay passage of the bill and throw a wrench to passing the bill. So, best case scenario is passes by Friday, signed by the president on Friday. Worst case is that we're waiting a bit longer, but the expectation is that the bill should pass. Just talk to you a little bit of kind of what the future holds now, looking past this bill, the third relief package passing. The IRS is going to continue to look at the extension of deadlines. Also, they've made pronouncements about easing enforcement actions that are currently experienced by taxpayers. Obviously, keep in mind how this will impact your current audits. If you're in audit position right now with the IRS, keep it in mind how those delays and would impact you as well. So keep that in mind. Also, Congress, as to what they could be doing again, and there's already chatter after Congress passes this third bill that they're going to pass a fourth coronavirus relief package in the near term as well. The focus would be on continuing relief for businesses and for workers. So a lot of provisions that perhaps did not make it into this third package presumably could be lined up for this fourth package. So obviously if the economy continues in a downward slide, there'll be more pressure for a fourth package sooner rather than later. I think something to keep in mind is that the longer this, the economy continues to stall, you could see Congress looking to other non-crisis specific provisions to include in any future tax bill. Next slide, please. A couple of provisions that I think that could be considered put this in the non-crisis category could be going back to provisions that were left out of past negotiations, tax extenders provisions, technical fixes to the Tax Cuts and Jobs Act, which a lot of folks in the business community have been advocating for, increased expansions to the earned income tax credit, child tax credit, which is championed by the House, renewable energy provisions as well. Those are provisions that I think that members have been working on for a while, and they could be looking to enact. Also look to additional middle-class tax relief, something that the president has been talking for a while. Infrastructure investment as well. This could put pressure for Congress to finally act on increasing infrastructure investment, retirement, and then additional changes to make permanent from the Tax Cuts and Jobs Act from 2017 as well. So leave you with kind of it's very important to kind of continue to monitor these congressional tax developments as we are expecting additional tax relief as well. Just something just to keep in mind, since we are speaking to the NCMA and the government contracts community. Something to keep in mind is that the third relief package that Congress hopefully will pass by tomorrow has significant increases to a number of agencies in their funding. The Department of Agriculture and FDA, an increase of about $48 billion of appropriations. The lion's share also goes to the Labor Department, HHS, and Education, about $172 billion of increased funding, and then Department of Defense about $10 billion. So just something just to keep in mind that 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 these agencies obviously are going to have a lot more resources to combat this crisis, and I think expect that to continue throughout the year. I'll pause there and go back to Abby. Thank you.
Thank you so much, Jorge. And thank you everyone for joining us. Now is the perfect time to pepper us with your questions. If anybody has any questions, you can shoot them to that email or you could hit the chat function. But if not, feel free to get back to us later with follow-up questions if issues come up. Like I said, we're here to help. So thanks for joining us today and good luck. Stay safe, stay healthy. I don't see any questions popping up, so we will hopefully see you soon in person.